The U.S. Supreme Court ruled this week that a lawsuit over Colorado's Tabor Amendment will be sent back to the 10th U.S. Circuit Court of Appeals. Opponents of Tabor have tried to overturn the law based on the argument that it takes away taxing authority from the state legislature. Again, Penn, we go to you on this legal issue. What does this mean? Is it a victory for the opponents? Is it a victory for the proponents? What is it?
You know, it's a great decision because everyone's declaring victory and they're ready to go home. So it means victory for everyone. Now, this case is still pivoting around a very preliminary issue, and that is who has standing in the legal context. That is basically who has the lawful right to bring a case to challenge the validity or the applicability of Tabor. That's the only issue really on the table right now, who can correctly raise the issue. And opinions vary. There are many who believe that the way the court sent this back to the lower court in light of another decision sort of implies that if you look at the other Arizona decision, some will argue, well, gee, standing was granted there only for specific things and particular reasons that don't line up in this case. And others say, well, gee, that was a case where you're applying specific facts to the law, and we think in our case we can make a same or comparable argument and that it'll be found that we can challenge Tabor, then we can get to the merits of this. In the meantime, there are efforts in the background to start raising some issues among the electorate and perhaps put some things on the ballot that will resolve this issue or at least address it through an electoral process. This is going to be a long time before we have an answer to this. It is fascinating to watch because it's got a combination of substantive law, all of the procedural quirks you could hope for in a court case, and the drama of bouncing up and down through the federal judiciary, which moves much more slowly than the state courts do. So this will be around for a while and interesting reading and watching.
Ed, do you feel that opponents prefer the legal route of trying to work on Tabor rather than the electoral route?
Absolutely, and I mean, you can just tell that by the fact that, remember, there are a lot of people who are talking about fixing Tabor, but when they talk about fixing Tabor, they're talking about removing some of the restrictions that Tabor has placed on the use of state funds that come in. You know, the very specific formulas that have put some to education through Amendment 23 and contrasting with Tabor and some of the other laws in there. Nobody in the legislature has come up with the proposal, hey, let's stop letting people vote on tax hikes. No, it's about as anti-populist a movement as you're going to find. I mean, and what's really surprising is that there are 3 legislators who are plaintiffs in this case, none of whom have ever introduced a bill to try to ask the voters to repeal the tax requirement vote-getting provisions of Tabor. So yeah, I mean, I think they see this as a legal route, and I do. I think if this were to become a political issue, I don't think a lot of people are paying attention to the court system right now. If this were to become a political issue, I think it's got some backblow to it. This is not just a Republican versus Democrats issue. I mean, yes, Democrats may want to be able to bring in more money for some programs that they support more than Republicans, but I think if you go out to the general public and say, hey, do you want to be able to vote on whether to raise taxes? I'm pretty sure a large number is going to say yes. So I think this is going to have to be determined through the courts. I don't think it is a legislative issue.
Patty, what do you think? Is this just one more chapter in the long issue of fighting Tabor?
The endless fight against Tabor. It's so amazing to think in 1992 we voted for Amendment 2 and we voted for Tabor. And Amendment 2 got tossed pretty quickly by the Supreme Court. But here, 23 years later, we are still just beginning the legal arguments in the courts about over Tabor. And we still are hearing there are going to be fixes proposed in the legislature, but we don't really see the will to push them through. We're going to have a couple ballot measures in November, including the marijuana tax ballot measure that'll come up, which will remind people what Tabor does. And I think Ed's exactly right that people like the idea of being able to vote on taxes. There still are some clunky parts of Tabor that need to be fixed, and someone in the legislature is going to have to take that on someday.
David, what's your quick take on the decision?
It's been the anti-Tabor lawsuit has been fatally wounded. David Skaggs is an outstanding lawyer who will try to prolong the death process as long as possible, but the end is inevitable. The Supreme Court vacated the decision of the 10th Circuit saying that a handful of legislators has standing to sue. And the Supreme Court in the Arizona redistricting case said the Arizona legislature has standing to sue because it was the Arizona legislature as a whole by an official act of the legislature, and they said, we vacate what you did in the 10th Circuit. Now, why don't you just think about it again, taking into account what we said about Arizona? That's a pretty clear signal. And if the case ever got to the merits, Justice Ginsburg issued a ringing endorsement of the people's right of initiative and referendum, and as part of democracy, and said even though the Constitution says the legislature has to do congressional redistricting, if the people want to take that away from the legislature and have an independent commission do it, they can, because all legislative power comes from the people. So that's the end of the merits of the case, should a court ever get to it.